Good morning, everybody. Welcome to the interview room. We have a little time here. We're going to cover the gag order hearing, I guess, that just popped up last night. Just heard about it. I want to thank Laura, one of our mods, for pointing it out. We just got home from a family wedding up in Michigan, and didn't get in till late last night, but what an absolute treat it was to see Karen's sister tie the knot at her house. They used her backyard as the place to, they had a little gazebo and everything up there, but it was an absolutely fantastic time. Karen danced my legs off, as you can imagine. Anyway, but it's exciting to have you here this morning. We're so grateful, so appreciative of each and every one of you. I know this is a last minute situation, but I thought it was important enough. I guess the court's going to announce whether or not the gag order gets lifted before the impact statements or after the impact statements. We're going to see how that's going to go. But how have you been doing? Let's see who's here. Gray is the new black. Good morning. Paper flower bloom. I love that. Good morning. Great to see you. Lisa Clear. Tina Davis, thank you so much. 6 months with us. We are grateful. Seeking Justice. Hello. And Buddy says hi. Buddy did really well. He went to the wedding too, by the way. And he just absolutely had a great time as well. Missy Blue, thank you. Carla Bergeron, excuse me. Forgive me for pronouncing your name inappropriately. Hippie Grandma Bargains and Nina, woohoo. Rhonda, back at you. And let's see here. Rhonda Ray, you have been with us for 45 months. Wow, thank you so very much for sticking by the interview room. I mean, even all the mishigosh that goes on out there, right? Hello from Oklahoma City. Great to see you, Martha. Let's see, who else? We got everybody's here. Hang on. Excuse me. L. Kennedy, hi from Texas. It's just so neat to see everyone here. We had a lot of people that had come in. Wow. Sorry about that. Ohio's in the house. Boise, Idaho. Dana Tossa. Caroline Miller, bless you. Thank you. I appreciate that very much. Let's see what the court is up to. Make sure I got the stream up here correctly. Let's see if there's okay, so obviously they haven't started, but when they do start, I will make sure that we are 1000% live. Angelico, thank you so much from Cali. It's great to see you. I look at that name. What part of Cali are you from? Looks almost like my sister. And she's in NorCal. Let's see here. Margaret, as always, we know Margaret, 50 months. My goodness, so great. Tulsa is a great little town. Tulsa is a great town. Hi, Shirley. Good morning. It looks like we're down to 13 minutes here. Hi from Tulsa again. Excuse me, I put that up twice. Ashley, grew up in Oceanside. Old Oceanside rocks back in the day, as you know, and what a great town it is today. I mean, I was part of the generation that laid the foundation for all these hotels and tourists, Yeah, this is a great question, Mavi. Why is there a gag order anymore? Technically, until the court, all the proceedings are done, then you can't, the court can still, hold the order up. right? And that's what we're going to hear today, whether or not he's going to hold the order up through uh, the impact statements, or if he's going to release the order. Once he releases it, it's going to be all out. Here comes everything, because what I mean by that is of course, the media is going to just go 1,000 miles an hour. I mean, there's already Patterson's book out. There's the movie's out. One Night Night. Oh, if you've not seen the program on Amazon Prime or whatever, I think you should watch it. It's a good piece of journalism. Um, there is some there are some things that I wouldn't necessarily agree with, but this is about the families, and those two families had an opportunity to speak, and that's up to them. Um, so let's ask this question. L. Kennedy says, "What do you think will happen today?" Well, let me turn that back on you guys for a moment, if that's okay. Um, what do you think is going to happen today? My feeling is once the gag order is lifted, then like I just mentioned a moment ago, the media is going to just go 1,000 miles an hour at this stuff, and they're just waiting to press, send, and the court's going to get overwhelmed with FOIA requests, as will the PD. So they're going to probably be um, uh, a lot of arguments, pushback. And so I think today we're going to see maybe the defense trying to push back and hold as long as possible. As always, with the Ann Taylor style, is delay, delay, delay. But what's going to be interesting here is I think we're going to see Bryan in his new jail wear, preparing for prison, and that'll mean he's probably going to be in a jumpsuit of some sort, not the kind he bought on Amazon or at the Dick's or wherever he bought all of his stuff. Um, he's going to be in Idaho orange, if that's their color, for DOC, Department of Corrections. Remember, they have to have different colored jumpsuits for the areas that he's going to go into. What you know that for segregation purposes, in terms of for his safety. Uh, he was we saw that he'd been arrested in Pennsylvania. You can find it through the arresting agency where he was arrested, whatever county or agency, and then through the court system. Go to that court, the Superior Court, look up, do a public record search. And it depends on the laws there in that state of how much information they will reveal. 100-yard orange. Exactly, Dana. Okay, here we go. We've got some movement here. So let me see what's going on over here. Let me pull that up. Okay, so we've got the court up. Looks like we're going to be ahead of it here. Perfect. So I think, let's see here what I've got here. Whitney says, Chris, I read that they are wanting to keep the gag order due to the amount of death threats happening to not only Kohberger, but court staff. Is this par for the course? No. It's called the First Amendment, right, Whitney? The court can't keep the right to the public to know because somebody is, getting threats and stuff like that. I mean, just look at, some of the high profile cartel cases out there. Can you imagine how many death threats and that kind of stuff comes in? So I hope that that's not the case. And you are very welcome, Whitney. Thank you for that question. That was great. Um, I've heard different things on this, Caroline. Have his parents or sisters been interviewed yet? I mean, Dr. Bricato, Gary was on. If you haven't had a chance, go to my community page. I posted Vinnie Paladin and Gary. They did a program yesterday, and it's really good. I mean, it's Vinny. I like Vinny. That guy is awesome, and obviously a former prosecutor that never fails to help the situation. But anyway, the thought was, when at some point is this gag order going to be lifted up, and what are going to be the excuses now that are going to come down that says no, these arguments are going to be really interesting. You hear this morning with Ann Taylor. But real important here, I think let's pay attention to now that Robot Man has been basically convicted. He has pled guilty to all four of these homicides. That let's watch his reactions, because he is just so robotic. As we've said from the very beginning here, the type of personality here is going to be, this type of guy. And, Robot Man, exactly. Yes, Lori, Karen, and I are planning on going up to Denver this year for the first time. We're not going to get a booth or anything. We're just going to walk around like everybody else. So hopefully we get to meet you and, give you a hug and, get to know some of you in person. So that's going to be pretty exciting. But let's see what Robot Man does here, right? How is he going to react? I don't think we're going to get much more out of him just yet because he is so robotic. However, his circumstances are changing. And the one thing that he has to face here is the fact that, his nothingness is now put out there for the world to see. And also, and thank you for Fugitive Recovery, and thank you for being with us. And we love Plunder. I mean, she is amazing. That she's a real journalist, that one. I mean, that gal, man, I watch her show all the time. I have from day one. And she's just an amazing human being and always ahead of the curve. And the one thing that, as you guys know about Karen and I, we're not a breaking true crime channel. I mean, stuff like this, these hearings, we promised we were going to cover it all through Kohberger. But the Plunder is out and ahead. And man, oh man, I guess when you watch that series, One Night in Idaho, which I would recommend if you're just getting back into us here today, go watch it. It was really pretty good. But you don't want to be on national television or in a primetime series as a YouTuber, across the world. Thank the Lord, we got it right. So, it's really interesting to see how this is going to, continue, right? And one of the things, as you all know, we say all the time here, even when I'm a little feisty, that facts matter. They have to matter for the victims and the peripheral witnesses like Dylan and Bethany and, Hunter and his girlfriend and all the things that went down. Those poor people, when you watch that program, it's exactly what Karen and I have tried to prevent. And, we get a lot of hate for that, but that's okay. People say and make up things all the time about me and about the channel or whatever. But the point being, we're accurate. And you can go back in our playlist through this whole thing, and you'll see that we were right on target. It's always neat to see some of that stuff come through. Sorry, I got a couple of big trucks going by. Hello. Anyway, so a couple of big trucks going by my house here, so I apologize for that. Thank you so much. I love tacos. I do too. Future, thank you so much for becoming a member. So let's see what the court's up to here. Go over here. I think it's going to start pretty soon. If we ought to probably talk to his principal, I forget her name, Dr. Ramslin. That's one, but there's also a second one in DeSales. Remember, she wasn't the only one. Dr. Ramslin only ran that crime house. There are other professors that he also was engaged with. So let's not forget that. I think that stuff's going to come out ultimately as well. So, let's pay attention to make sure that we understand, it's just not Dr. Ramslin. I mean, Dr. Ramslin is, doing her own thing in terms of, what happened to her. But there's going to be so much information coming out if this gag order is listed. So, okay, there's a 1 minute approximately. And the gag order was from top to bottom. Nobody can talk about it involved in the case, any court staff, any law enforcement, etc. That's why some of the stuff that was leaked to Dateline kind of moved this thing along, in my opinion. And thank you, Angel Rock. You're so kind. Yeah, thank you for being with us for 13 months as well. And Maui Girl, thank you for being here this morning. Aloha. I hope, and let's not also forget the folks in Maui that are still suffering from the fires, the folks in Paradise, just so many crazy things going on. Now we've got the flooding in Texas and in New Mexico and tornadoes in North Carolina. Man, there's a lot going on. There's a lot going on in the world. And then we carve out these special occasions, right? These special occasions of marriages and that kind of stuff. And welcome, Santa, from Sweden. I don't know how to say grateful to have you here in Swedish, but I'll say it in English. It's great to have you here. I am well, and thank you for asking. My voice is just a little run down because I had a great time, like I mentioned, at Karen's sister's wedding. And it was just an amazing wedding. I mean, she used her backyard up there in Michigan, and it was on a lake. It was just nuts. It was great. It was a lot of fun. So let's see here. Okay, I'm not going to try to I'm not going to try to pronounce that, but especially with my voice here. When I was younger, I had a little speech impediment, and I was always self-conscious of that. And every once in a while, I'll screw up a couple of words, and but anything. Thank you, mitzvah. What a mitzvah. Hello, everyone. Love the UK. Peace and love. Thank you so much. What a mitzvah. It's great to see you. Hello from Laguna Beach. Taffy. Great to have you here. Love Laguna Beach. What a beautiful area that is. Mountain Cat. I wouldn't give him the satisfactions of my victim statement. I would agree. Yeah, he's waiting for, them to do all of that stuff, and he's not going to lose a beat. And I'm not sure if if Catherine Ramsden gets in to talk to him, he's just gonna play her. So you just have to realize that right now from the beginning. Let me refresh this, make sure that nothing's happening over here. Okay, nothing's happening. So the court's holding on here for a second. Tamara, welcome from Tennessee. Great to see you. Years ago, Karen and I lived in Spring Hill, right there outside of Franklin, many years ago. What a beautiful area. Great, amazing people. Mountain Cat, yeah, he thrives. Hi from Norway, Monica. Hello. Thank you for being with us. Alberta, Canada's in the house. I think if a guy like Gary got in there, or people that deal with those kind of personalities before they're even caught, what's really always interesting, and the one thing I loved, about being an investigator was, you get to sit down with these guys and then, try to figure out why they did what they did. And then you get to put them in the container. And then all the doctors and lawyers and everybody gets involved, and they can figure out what makes them tick. Mary, New South New Orleans, sending lots of love. Thank you so much, Mary. It is so great to have you here, and thank you for your kindness. You're awesome. Let's see here. Let's see who else we've got. Good morning from the UAE. Oh, wow. Hello, Rhino Girl, United Arab Emirates. Thank you so much. What a beautiful country that is. An area. I mean, one of the cleanest cities in the world. Bless Insta. Oh, thank you, Bonnie. It's great to see you. And thank you for your kindness. So what have you guys been up to while we're waiting? Do you think the judge is going to lift the gag order here this morning? I'm not leaning that way right now. I think that the judge is going to, he's going to, hold off. One of the things that I was disappointed in, I thought the program one night in Idaho was very well done. I mean, we all have to, give credit where credit is due. But the one thing that I again was disappointed in is the fact that the university controlled so much of the narrative. And they did admit on that show that they were not prepared for anything like this, where they thrust the mayor out there. Thank you, Holly, for your donation. We're grateful. They admitted, they finally came out and said, yeah, guess what? We weren't ready. Okay. And that was obvious, right? Any one of us could figure that piece of the puzzle out very early on. There is, and there was, no way they were ready for anything like this. And then, of course, you thrust them into the public, court of public opinion. And it became apparent rather rapidly that they weren't prepared. They didn't even have a PIO at the police department. I bet you they have one now. And so what they did is they plugged in the communications department at the University of Idaho. And what the heck, what do they know? What do they know? Nothing. I mean, these situations are so rapidly coming at you. I mean, one of the things we've trained at the Cold Case Foundation, and one of the things, you learn as a homicide detective, is you're making about 300, I think it's, 360 or the 400 decisions within the first hour of a homicide going down. And if you've never experienced that, okay, the other side of that coin is within that hour, you also have to realize, okay, there is no room for mistakes. So those decisions have to be 100% on target, on target. I'm going to refresh this one more time to make sure the court hasn't come up, which they have not. So it looks like they're running a little late. And so there's nothing like, and so this is why protocol and standardization, some agencies have checklist that you carry in your car, you break your file out and you go A, B, C, D, and you just follow that checklist. And with the book we got coming out soon from the Cold Case Foundation, we have, it's going to be a really great book. And we hope you're going to pick it up here. That we go over different things on what homicide investigators, what the protocols should check. And it's going to be a check and balance kind of thing. But we've kind of modified it a little for the public. So we're not giving away a lot of the secrets to, law enforcement. Thank you. One Big Doodle. Love that name. Thank you so much. But it's going to be a really great read. We hope you're going to pick it up. It's going to come out probably in the fall. It is being published by McFarland Books. So it's a big deal. And I'm not at liberty to completely talk about it yet, but Gary and I are on the cover. Okay, here we go.
All right, we are on the record in State v. Kohberger, CR 0124-31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would
Who
only
cares?
increase the concerns that the defense has.
The-
And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you.
Who cares
All
what he
right,
thinks?
as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. And at this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed.
He's
or
going for
outweighs
it.
those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like a, water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request.
Watch Ann Taylor's face
for
and
example, the
Bryan's.
defendant's family and others coming and going at the sentencing.
And he's in his new jail
intend to
attire
have,
for
as we
prison.
did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I
Right
think the
on.
rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case. And so I'm going to lift the non-dissemination order.
Boom.
But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all.
Everybody just
Second
press
of
send
all,
right
I
now.
want to
Everybody
be
just
clear
pressed
that
it.
the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so
As
it
we
may
said,
affect the outcome of that appeal, and it may affect
this
the
is
underlying
why
case
the
and
families
plea
are so
agreement.
upset.
But nonetheless, the
Right
right
here,
to
he's
appeal
saying
does
it.
not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about?
We'll talk
the
about it,
ruling
Jen.
today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
So Olson, do you have any
And
questions?
I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
Okay, so what does this mean? Right, let's break it down real fast. Okay, so a couple of things. One is Kohberger is in a different color, number one, because he's being prepared for Department of Corrections, and sometimes, depending on what pod they have him in, if it's a max, then they have different color schemes within the county to show that somebody is in pretrial. So they may wear a different color. Somebody's actually in trial. They won't necessarily wear a jumpsuit or a different color. They'll put them in their, court attire, which we saw happening, during the some of the hearings. And then once they are either found guilty by a jury and or take a plea deal like this, and if they decide, okay, what's this guy's threat level? What's the threat to him? Where's he going to go with inside of the court system, i.e. the jail, until his sentencing, the impact hearings. And once the impact statements are made, he's done. And so literally they take him out the back door. They may pit him for 24 hours. And then the Department of Corrections comes by and picks him up. And that's why he's in a different color. The different color tells the jail, and they have different color wristband as well with inside the other side of the coin here. And once this is all done, they don't have to figure out, okay, where's this guy going to go? They already know he's prepared for Department of Corrections. He's wearing the right, jumpsuit, and they're just going to put him in a van, and wherever he's going to go, and he's off and running. Okay, so that's the color. Number two, the big takeaway here, yes, the judge is going to partially lift the gag order. So what he's doing is he's breaking bread for both the defense and the media. You notice they had a media, representative, an attorney from the media, and the prosecution to lift what type of information, right? One, some of the gag order, or some of the sealed information, what the judge is saying is not until the hearing, i.e. the impact statements, are done, is he going to start releasing any of the sealed information. However, before that, he's giving a bone to the media to say other stuff, which, it's going to be like the search warrants, probably no photographs or anything like that, may or may not be body camera information, etc. But it's the stuff that you can't hide from the public. The public has a right to know under the Constitution and the First Amendment and journalism, freedom of speech, and freedom of the press. So they have a right to know. And this is why you saw that attorney there. They had also filed a brief. The court read all the briefs and said, okay, I'll tell you what I'm going to do. I'm going to break bread. And that's basically what he was saying. I'm going to give, the media something so that he answered up. and presented them an opportunity to say, okay, are you okay? But I'm not going to give you everything yet, not yet, until this is all done. And then it's going to come out in increments. Now, that is going to be a controlled flow of information, which, man, I'm telling you, that's got its pluses and minuses. If you didn't watch the Idaho, A Night in Idaho, the new, Amazon Prime thing, you saw that they weren't prepared in any way, shape, or form. And my Karen, who's been a PIO, she's been a journalist for 35 years, she came out and said, these folks don't know what they're doing. And guess what? They didn't know what they're doing. And in that show, they admitted they didn't know what they're doing. Okay. So some of this information is going to be, right at us. We're going to get some, but I think what the judge is also worried about is how do we balance this release into the public? I am always concerned that the University of Idaho is controlling some of the flow of this information. That is not how you do it, because those kids that suffered through the social media backlash is a direct result, in my opinion, on the University of Idaho. Their communication, I mean, they had their doggone communication, or their, whoever the dude was on the show, he's in every press conference. I'd never seen that in 42 years in this business, where you have a private entity standing behind and with law enforcement. If anybody else has seen it, please show it to me, because that is like law enforcement number 101. You don't do that, because that's how you get leaks. That's how you get misinformation. And guess what? For 3 days during this whole case, they didn't put anything out there. And so the public, the beast, as we call it, right? If you don't feed the beast, i.e. the media and the public's right to know, then that's how all of these rumors start. And I mean, it started that day with those poor kids who discovered, the victims, sitting outside, and the cops weren't telling them about their other two friends until they got a Vandy alert. I mean, seriously? Okay, that aside now here's the takeaway for the day. This will be the headlines. Bryan Kohberger could get an appeal. What we just heard the judge say, and one of the things that we've been talking about on this channel, is there is always an opportunity. And what the judge just said, even though he pled and said no possibility of an appeal, what did the judge say? But the Supreme Court said, and he cited a case that basically Ann Taylor, I guarantee you, has already pressed send or is already meeting with the appellate attorneys. And what this means is this: he's going to go to Department of Corrections under the umbrella of he signed a deal, okay, that said he does not get an appellate opportunity. It doesn't go to the next court now to say, well, there was a problem over here, there was this information over there, there was this ineffectiveness of counsel. All of these things can be brought up, okay, in the appellate court in a brief. Okay, what I mean by a brief is, just like we've been seeing, I've said from day one, Ann Taylor is shrewd and doing her thing. And she used all of the briefs and, all the gag order stuff, all of that through the system without opening her mouth. she would put it out, motion to this, motion to that, motion to this, et cetera, et cetera, et cetera. Okay. And she gets out there, gets it out into the public court of a public opinion, i.e. people talking. And then what happens during the hearings? She comes up and stands up and says, what she says, right? There's no way my guy did this. We 100% stand by him. And then what she does is she adds color and filler to those motions that she files over here that she knows is getting around the gag order. She did it again. So this is what this means. The judge just told the world, yes, I know, and you heard it, you saw it, the world, that he signed off on an appellate opportunity here. But then he qualified it. And this is why the family, Kaylee and everybody, and quite frankly, the other families, they just got hoodwinked. Because what the judge just said is, even though that is in the agreement, this will be the headlines. And I'm here to tell you, folks, you heard it first here on the interview room from the day I started this one and to today. Okay. This case isn't over. Bryan Kohberger may sit in prison 5, 10, 15 years, but guess what? He's going to appeal everything. Mark my words. Remember, we talked about the Menendez brother effect. Okay. And the families are sitting back going, okay, it's over. We're done. I'm glad he's going to rot and wherever. Okay. But what the judge just said was, he can appeal, even though there's an agreement that says he can't, because the Supreme Court said he can. And so when we're done here, he can go back and listen to the verbiage of what the judge said on this. Okay. Now, I've put a lot of murderers in prison, and every one of them appeals. They always do. And it goes to, the appellate court, and a whole new set of attorneys jumps in. And then they go through and they read every word of every hearing. And they look for mistakes that the prosecution or the defense made. And then they take those mistakes and they build off of those mistakes into the appellate court. And what that means is it goes to another court, and they are going to listen to the story of people versus Bryan Kohberger. And Bryan's just going to sit back, tell his side of the story to the world, whatever that means, whoever that person or persons are. Okay. And I think this is one of the reasons why, Kaylee's family has been and is so upset. They feel like they've been manipulated by the court system. And the other families, who are, remember, it was 50-50. Two families wanted it, the death penalty, and two families did not. At this point, it may have been a better move to make him go before a jury. Because at that point, once a jury hears it, the appeals process kicks in to the sentencing phase, i.e., should he be put to death? And a jury will then make a decision on that. And there's a whole hearing and, court process that takes it back. And you present that in front of a jury. And from there, if he's found guilty and the judge says, if a jury comes back and says, yes, we vote death, then the judge has to sentence him to death back if that would have been the case. And then from there, that goes to the appellate attorneys. And, that goes through the system for decades. And they pick apart. Well, wait a minute, the jury should not have sentenced him to death. Okay. Well, that's what the judge just said here. The judge just said to the world, even though he signed off that he would not have an appeal, what the judge just said was, but the Supreme Court has said it's possible he could have an appeal. What he signaled to the world is this isn't over. This is not over, is what he just said. It's going to be over for us because he's off to the, to the pit, okay, i.e. Department of Corrections. But for the families is what Judge Hippler just gave him a heads up. And this is exactly what Steve and Christy and the other families have been saying. We feel like just take this thing right, to the court, i.e. to a jury, get it going, let them have their time and put it out there so that everything can be heard. Now think about this. The defense in this thing has strategically positioned themselves into here's the way I look at the defense in this thing, which they're doing their job, by the way. I can't argue against Ann Taylor or the defense. I can't do it, or the prosecution. Okay. I've said many times the prosecution is being out-lawyered. Okay. Now she's sneaky. She is sneaky, and so is her team. Okay. Remember when the house was torn down? When the house was torn down, what did Ann Taylor say? Where do I sign? Absolutely. That's an amazing idea. Tear it down, make it go away. Okay. And guess what? They did. They made it go away. And anybody in my field, we're all looking at each other going, did they just tear the house down? Of a quadruple homicide? Is it gone? Okay. This is the time when those decisions would have been made. It would have gone away at this point. The university can pick up the phone and say, bring the wrecking crew over. He has pled guilty. Okay. Boom. It's gone. Okay. Because there is always going to be something in our system that is going to lean towards the defendant. Remember, before a jury convicts somebody, the defense and the court will look at the jurors, and those of you who have served in a jury know what I'm talking about. And those of you in other countries, Bosnia or Sweden or etc. In the United States, Lady Justice has two scales, a blindfold, and a sword. And each one of those stands for a significant part of our system. Balance, for justice, blindfold, the court, Lady Justice doesn't care who you are. And then the sword is like swift, get to it. okay, in the Sixth Amendment. Okay, just make it happen. Okay. So the judge knows all of this. Ann Taylor knows all of this. She has positioned herself or positioned her client for the appellate process now. For the appellate process. That's what she's done. Now, whether or not he gets an appeal, it will be argued. Is he entitled to an appeal now? Even though he signed the documents that said, I'm not going to take a plea deal or an appellate deal, meaning he could not have gone to a higher court to hear his case. Okay. That was the deal that they signed to take the death penalty off the table. But what the judge just reminded the world, and I know I'm repeating myself, but it's important because people keep coming in. Okay. What the judge just said is, well, yeah, we know that he signed this deal, but the Supreme Court has said and then he cites the case, it's possible, is what the judge said. So nothing is off the table. So think about this. He hears the impact statements. The families put their hearts and their souls into it. And he goes off to prison, Department of Corrections. He's sitting in the Department of Corrections, and his attorney, Ann Taylor, who touched him during the plea deal. Bryan, I did my best for you. I'm so sorry, but don't worry. Don't worry. There's still a way. That's what happened today. And so the death penalty is off the table. Yes, Kennedy, the death penalty is gone. That piece of the puzzle is over with. They cannot file death. It's over. However, as Carol says, that's law. Okay, Caroline, she's correct. That is law. And so I've said from the beginning that Ann Taylor has out-lawyered the prosecution in this one. The prosecution got out-lawyered. And you can't fault Ann Taylor for that because that's her job. If it was anybody in the world, that's why our system says you get an attorney. Okay. But now that puts the families into even a worse situation because they're not necessarily going to be able to say what their feelings are in the appellate court. Because what the appellate courts are going to do, that they're going to read all of the documents. Okay. So our system is tiered in levels. Okay. And what Ann Taylor is going to do is prepare all the appellate briefs. That's what they're called. So because she's an appointed public defender, she's done after this is sentenced, or excuse me, the impact statements, and the court says, boom, case closed. Okay, he hits the, I'm just using the gavel as an example of, case closed. Boom, case closed. And everybody goes, oh, we're done. Okay, he's off to prison and yada, yada. No, we're not done. No. This will be the headlines in the world. Because even the court had to admit today that, and he didn't say it, but he implied it. You did a good job, defense. because you got this thing taken off the table, i.e. the death penalty. And yeah, you have it in writing that he can never appeal, but you do know that the Supreme Court has said there's always a way, especially in this kind of case, a murder case. And I've had subpoenas and, gotten phone calls years later. Even after I retired, I had to go testify in a case in San Diego, that happened in 1991. Hey, are you still alive? Basically, the phone call. Yeah, you're talking to me, and hey, by the way, this guy is blah, blah, blah. And it went through the appellate court. I'm like, what are you talking about? I mean, that's a slam dunk. It's never a slam dunk. So it's not going to go to the Supreme Court. It will make its way. Okay. It'll make its way to the appellate court. And the appellate court could say, hey, we have some problems here. And the appellate court in Idaho, I don't know what district it is. It could be the Ninth Circuit even. It could make it to the Ninth Circuit. We used to call it the Ninth Circus. Okay. And if it makes it to the Ninth Circus, oh my gosh, put your seatbelts on, everybody, because that's one of the craziest courts in the country. I've seen them reverse situations and say, hey, you need, et cetera. Here, I think this is the case. Thanks. In America. In Garza versus Idaho, the defendant signed plea agreements that included appeal waivers, explicitly giving up his right to appeal. Yep. And that's what the judge is saying. He can also argue, okay, that maybe he didn't understand because of his autistic, incapabilities. And so the appellate attorneys, if they're as shrewd as Ann Taylor, they're going to read every single word and find that all the T's and the I's had better been dotted and crossed. That is what the judge is warning the world about. And so once this stuff gets released, now, what does that mean? We don't know. Could the court say, you know what, we think that life imprisonment's too much? And it could keep moving, right? So Bob says Idaho is within the Ninth Circuit. There you go. And Bob would know. So it is the Ninth Circuit. Go look up the Ninth Circuit Court and read some of their decisions. Some of it is crazy. Bob and I both worked in California, and all of our appellate information would go to the Ninth Circuit. And it's crazy. Sometimes, some of the decisions they would come back with, you'd go, really? Wow. Wow. But that's our system. And, at this point, the impact statements now are going to be even more interesting for these poor families. Even the ones that signed off that, we want it over with. It's not going to be. It will be in terms of out of sight, out of mind, because a lot of this information will be happening behind the scenes. Don't be surprised if some other dude information comes up in the appellate briefs. Okay. It's going to be very, very interesting how this stuff starts getting channeled now through the court system. So the bottom line here today in the hearing is the judge is breaking bread with the media, the defendant, i.e. the defense, and the prosecution. He's telling all three, I will release the gag order on some things, that he will allow some of the sealed information, which is, obviously for anybody with date of birth, social security numbers, any of that stuff is still going to be remain sealed. And that at some point in increments, the court's going to give an order, and it will be a single order, I suspect, where he's going to give release dates on information. That's a possibility here. Or he could say, we'll have another hearing on this, and this, because the media is going to push. We have a right to know. We have a right to know, i.e. the public has a right to know. And so the media got today some things. So right now, everybody press send into the FOIA request. And that in of itself, right now, the court has been bombed. Once the order comes out and is signed and it's posted, that's when those buttons will get pressed. And it's on, game on for the media. You think the Idaho 4, now this is where the movie people come in. This is where, 48 hours, Dateline, all the big, conglomerates step in and say, let's go. Okay, game on. But what the court just said was, well, you're only going to get some of that right now. We're going to release the other stuff in increments. So that's the big news on the gag order. The second big piece of this is what we just talked about, the appellate order. The appellate discussion. The judge has no control over the appellate discussion. But what he did was tell the world, hey, there are cases out there. And he cited a Supreme Court case. So what the judge said, remember, the Supreme Court is the law of the land. That's why it's called the Supreme Court. It is the law of the land. So every other court in the world, in the United States, has to follow the orders of the Supreme Court. They have to follow it, or else our country just falls apart. Because if you don't follow the court, who are you going to follow? If there's no yellow line in the middle of the road, then two cars collide. Who's at fault? And so the Supreme Court is that yellow line that says, no, the society, these are, you stay on your side and you stay on your side, and then two cars pass each other safely and everybody makes it home. So what the judge said was, and this may be an easy way to understand this for those in other countries that don't understand our system. So if we think about a line in the roadway, okay, like this for an example, okay, if you're driving this way, for an example, okay, and the other car's driving this way, all right, well, this broken line, this car can pass from this side, but this line here, this car can't pass. So if they collided and this car collides over here, this guy's at fault. So here's what the judge said using this analogy. This solid line, okay, is the plea deal. This is the plea deal. You can't pass that plea deal. Okay. However, what he said is this broken line is the Supreme Court rulings and case law about somebody crossing over into the oncoming traffic. Okay? And so what the judge said is, yes, this exists, but the Supreme Court said sometimes you can cross over. That's what he said today. And so that means Ann Taylor has just pressed, let's go. Let's go. About the appellate process. And so once the gavel goes boom, i.e. after the 23rd, when the family says all they're going to say, and the judge says, you know, you're sentenced to the Department of Corrections at, you know, wherever for 100 years. Okay. Everybody goes, oh, it's over. Yay. Okay. But, and Taylor sitting back going, Bryan, yeah, don't worry. There's more coming. Now, here's how it could end. If there is an appellate brief filed, which there will be, everybody, I mean, do you guys not think that Ann Taylor's not going to try to get somebody to file an appellate brief? Okay. Yeah, I guarantee you she's going to somehow file some. She's probably got it already, the template in her computer. Look how many hours or how many pages, you know, some of these briefs have been. Okay. And so once it's over, now she goes into phase 2. Bryan goes to prison. He's off to prison. And he has to figure out how to navigate now his new world. Okay. And, you know, he's going to come in and the inmates are already waiting for him. I guarantee it. I mean, they have TV in those pods and they're waiting and they're trying to figure out, you know, they're trading cigarettes as to who's going to be a cellie with this guy. That means a cellmate. Or is he going to go into special housing, which he probably will. And the special housing unit is called SHU, S-H-U, Special Housing Unit. And it's a prison within a prison is what it is. Those individuals are locked up for 24 hours a day, 23 hours a day, with 1 hour out into the controlled exercise yard. And they can get him out. You know, he gets 1 hour to come outside. Okay. But he's still going to have privileges. He's going to have commissary. He's going to be able to get books. You know, this is where you're going to start hearing the phone calls like Stefan Stearns, who's sitting in county right now, talking to his mommy and his daddy about killing Maddie in Florida. And we hear all those conversations that come out. If you want to hear a lot of that stuff, Plunder, she's fantastic. If you've never subscribed to her channel, you need to follow Plunder. She's an amazing journalist, and man, she can dig stuff up, and she gets a lot of that information. So I have no problem ever saying anything nice about other channels. So Bryan is going to get there, and the phone calls are going to begin. Mommy and daddy are going to call him, you know, thank you for saving us. You know, we didn't have to testify. And you know, Bryan, you really didn't do this, did you? Right? Hypothetically. That's a hypothetical. Well, no, Mom, you know, I do love you, blah, 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 et cetera, et cetera, et cetera, et cetera. Okay. So that's where all those phone calls will start. And the family can do that. They can there's a system that, you can put money on their books, you can put money on their phone calls. And in that 1 hour that he'll get out in the special housing, until things kind of, settle down. But while he's walking around in that 1 hour, he may have privileges. And those privileges may be access to email, maybe access to the dorm where he can watch TV, books, he can go to the library, escorted, of course, because he's in special housing, or he can order books in from the library. But he gets a lot of different things. Initially, it's going to be controlled because he's going to have to go through so much evaluation processes, right? He's going to have to talk to a shrink, hey, do you feel suicidal? Have you gone crazy while you've been in county, et cetera, et cetera, et cetera. And so they're going to do a medical eval. Then they're going to do a threat assessment eval where, they're going to ask him, do you participate in any gangs? Have you ever been in a gang? What do you know about gangs? Yada, yada, yada. Okay. And then what they're going to do then is assign him, okay, after about 30 days. It takes about 30 to 60 days to get this process done. They're going to figure out his dietary situations. They're going to figure out his medications, if he's ever been on them. And he's going to tell them he's going to give them these answers. And then they're going to do an assessment. And then that assessment will determine ultimately whether or not he will ever go into general population, or if his threat assessment's too high, he remains in protective custody in PC. And in PC, that's where all your RSOs are, all your snitches, all of those folks are in protective custody for, the reasons they're there, i.e., let's say a gang member wants to get out of the prison gang. Well, you never really leave a gang, ever, especially not in prison. But if you have been snitching on people, then the system, and you go to the system and say, hey, I need to tell you about this, okay, the system's going to go, okay, well, we're going to need that for the case, because remember, it's a city within a city. When we drive by prisons and you see those guard towers, right, in each one of those units, then within inside of those units are blocks of units. And they're called pods. Each one of those pods has a letter, A, B, C, D, and within those pods are all these jail cells. Okay. But then within that prison, in a max security 5, that there's another pod within the main prison, and that's called the SHU unit, special housing. And within that, depends on where you go. I've been into a lot of prisons in my time. The most secure prison I've ever been in is Pelican Bay in NorCal. And once you enter Pelican Bay as a guest, i.e. law enforcement at the time, you have to sign off that they have a no hostage policy, which means if you get taken hostage, they're not coming to rescue. You're on your own, dude. And so they make you wear, you can't wear certain colors, you can't bring in, certain things, et cetera, et cetera. And, you sign off all basically that, okay, if this thing goes down, i.e. a prison riot, and you're in it, and you're taken as a bargaining chip, you're going to have to figure it out. And in the special housing units, depending on how secure they are, and I do not know how secure the joint is in Idaho, but I'm assuming it's going to be pretty close to, the average special housing unit. And that means they have a catwalk inside the building. And they typically take the prisoners to the door. Let's say you're going to escort that individual. And they walk up to the door. They have the prisoner put their hands through a little slot in the door, the same place they get their trays. And they stick their hands out. They cuff them. They have them step away from the door. They give the thumbs up to the control room. The control room presses their pod number. The door opens. The prisoner standing facing away from you. You say, step back. Okay. They put leg braces on them, ankle bracelets. They pat them down. And in Pelican Bay, you have 2 escort guards and a guard overhead. You have 3 guards escorting the prisoner down the hallways. 1 up top with a weapon. The other 2 are side by side with less lethal, i.e. sometimes tasers or whatever they're going to do. Okay, so Bob says, I've been to Idaho Max. It's a typical Max. Okay, so what I'm telling you here is what it will be like for Bryan. Okay, when they escort him out and they're going to put him into another cage outside for 1 hour of exercise or whatever he wants to do. And there's Buddy, by the way, everybody. But say hi. Let me see if I can get Bud in the shot there. There he is. So let's say they're going to take him outside for his hour. They want to make sure that there are going to be no prisoner access to Bryan Kohberger for at least 30 to 60 days while they're processing him. Okay, and doing a threat mental assessment, all this other stuff. Well, Bryan Kohberger is a robot. So literally, they're going to get no emotion out of him. He's just going to go with the flow. Okay. But he's going to think he's a tough guy. But that's not the persona you want to be projecting in the joint at all. Because remember, there are lifers in prison that do not care about Bryan Kohberger. And, they have, blanket parties in these pods sometimes where, the inmates, they have, believe it or not, they have a code of conduct. And it's all about respect. You do not disrespect anybody. You just do what you're supposed to do. You do your time and you get out of there. And if you're not affiliated with any type of gang and you're just kind of there, you have to align yourself with somebody for protection. And he's going to find that out pretty quickly, that it's not like County where he was. Okay, where he was. Yeah, that's a great question on him. So when he gets into the joint, then they've already sized him up before he got there. He's already been sized up. They've already put he's going to walk in there with his package and his packet, and it's going to go to intake, and they may have trustees working the intake, meaning once he first gets there. Well, those trustees are prisoners that the system has said we can trust them. But there's a code of conduct with inside the joint. If somebody walks up to you and says, what do you have? Hey, this Kohberger guy, he's over in the shoe unit, pod 3, whatever, number 4. They're going to know where he's at in the system. Yeah, and Heather's right. I was under the impression that he wouldn't be in general pop for years. It's possible. It's possible they could roll him into general pop, but general population, but I'm not seeing that just yet as well. especially during this quote now opportunity for appellate. Okay. That, anything can change. Anything can change. I mean, he may turn into, the prison lawyer, right? He may turn into, the go-to guy. Hey, you've got a master's degree in criminal justice, criminology, psychology, etc. What can you do to help me on my case? I'll give you a cigarette. Remember, he also had an addictive personality. So does he fall into that problem as well in prison? Does he fall into, the drug situation in prison? I'm here to tell you, he is very vulnerable to that problem. Because some of the other inmates may say, hey, I hear you were slamming the needle on the outside. You owe me now. And they're going to try to tie him up. Do you think the plea was a move to get to a higher court and out of Idaho? He knew what they had way before the plea date. Was this his plan? You know what, that vet girl, that is a great comment. Of course, it's speculation to say that's possible. But at the same time, I wouldn't put it past Ann Taylor that, again, she played the system correctly. And yeah, anything is still possible here. And when think about the totality of what the judge said today. The judge explained what it meant for the appellate system. Guys and gals, that's huge. If the court would have, why did the court bring that into the gag order hearing? Why today did the judge say what he said? And listen to his verbiage very carefully. He said, and I'm paraphrasing, I know that the defendant has signed this order that says no, possible appellate opportunities. But then he qualifies it with, however, we also know there's a Supreme Court case and decision. And then he starts to break it down. So what he was really saying there was nothing is ever impossible. So prepare yourself is what he was telling the court. The court was saying to the families, put your seatbelts on. This is not over. And you didn't hear Ann Taylor say anything about, well, Your Honor, that's inappropriate to talk about an appellate situation in a gag order hearing. That's the story. That is the story today. Okay. Now, whether or not he gets an appeal, we don't know. What the judge is saying is it's not impossible. That's what he did. That's what the judge did today. And it's interesting. I believe he manipulated the outcome to this point. Thank you in New Jersey, Elena. Appreciate all discussions, coverage of this case. I love this channel. Thank you so much. You're so kind. Let's see here. Will the lifting, thank you, Cuba Forever. Will the lifting of the non-dissemination order have any bearing on the ongoing investigation by the special prosecution who leaked information to Dateline? That's a great question. Here's what I think is going to happen in that. It's over. That leak investigation is done. On the 23rd, the moment the judge says, and your sentence is, and here's the facility, I'm turning you over to the Department of Corrections. It's over. Just like he said in the last order, okay? Just like in the last order where he said Mr. Kohberger will no longer be in a suit and a tie, and we just saw him in his Ada County Jail attire in the upper left-hand corner. And that color is based on classification of where he's at right now in relationship to the jail system. And they may only have a couple colors. You know, I've been in jails where they have black and white. I've been in jails where they have orange. I've been in jails where they have yellow, green. And as they prepare them for certain phases, i.e. transportation into the Department of Corrections after they've been convicted, okay, they give them these different colors because they have to keep track of where he is in the process. And so that's why he's in this Ada County red right now in the upper left-hand corner that we saw. So the takeaway, right? Oh, I just see, oh, Laura, thank you so much. And this is Laura. She's one of our other mods. We love Laura. She's amazing. Let's see, look at all the winning. Yeah. I know, right? Yeah, no, I agree. It just doesn't feel right. That's for sure. Right, Julie? It doesn't feel right. But the other plus is this is our system, and our system has to work, whatever that means. If it does go up to the appellate courts, they could reject it. They could say, well, he signed a deal and it's over. But they're only going to do that after they read the appellate briefs. Only after they read the appellate court reads the briefs, or the attorneys. And Ann Taylor has all of this ready to go. I guarantee it. Ann Taylor is ready to make this happen. Now, here's the situation. So it's a 2019 case. Thank you. Garza versus Idaho. It's from 20, not that old. At being a death penalty attorney, knew what she was doing. There you go. Yeah. So the system, she has manipulated it using the law, using her skill, and has basically got the death penalty off the table, said, no problem, we'll sign the appellate signature here. What do you need there, Mr. Thompson? I call him Santa Claus. What do you need, Santa? Because, he just brought Bryan Kohberger a bike and gave the family coal. In my opinion, the use of publicity and info out, if there was a factor to his plea, oh boy, yeah, no, I agree. And now all of this stuff, the judge is going to say, well, I'll give you some of it now today, i.e. once he signs the order, they have to release it. The first people that get all of this information will be the major networks, because they have a wall of attorneys standing by. So they'll get all the information right away, and we'll start hearing it, coming out. And then the other people, a little bit lower down the food chain, will start getting information. So the takeaway for me and for Karen, for all of you in the interview room and with our channel, is it's not over by any way, shape, or form. And so now this is going to be really interesting to see how the impact statements go, because a lot of those families have felt this was a good deal and it's over with. Ain't going to happen, folks. Not yet. This could go on for 10 years, 15 years. And the difference will be the families won't have to go testify. But behind the scenes, there will be a law or a wall of appellate attorneys assigned by the state or hired by the family on some of these book deals to take it through the appellate courts and to argue. So it is not over. That said, man, let's wait for the next one. Okay. God bless the families and everybody involved in this situation from the victimization side. Yeah, it's crazy. Aloha, everybody. Love you all. Thank you so much. We will see you guys on the next one. Aloha.
Hard working every day, I'm stressed out 24/7, babe. No timeouts, wish we could fly away. You and I go to our favorite place. Oh yeah, make special memories together. I'll be your company now and forever. I say we fly away, you and me, go to our favorite place. Feeling the sun on my face in Hawaii. With you, Hawaii. With you, Hawaii. With you, Hawaii. I need a summer breeze, some fresh air to put my mind at ease. No cares. You wanna come with me? Me and you go to our favorite tree. Are you ready now? We jump on a plane now. We're taking away. Yeah, we're taking away. Don't hesitate now. We're taking away. Yeah, we're taking away.